Good morning, everyone, and welcome to the Fair Housing 301 training for rental professionals. Thank you all so much for taking the time to log on and join us this morning. We had a great response, and I expect we will continue to see more people joining us this morning. Our numbers are ticking right along. We are very grateful to MISTA, the Michigan State Housing Development Authority, for sponsoring this training series through a very generous grant. Hopefully you have been able to join us for our 101 and 201 trainings, which we offered late last year and early this year. We are offering a second series coming up in the spring into summer and 3 more special training opportunities. So we have lots more to come. Joining me online and assisting with keeping everything up and running is Lindsay Owens, our Education and Outreach Coordinator. So feel free to contact Lindsay if you need any assistance. A little housekeeping as we get started. We are taking attendance through the evaluation and survey link that we provide at the end of the class and then send out later. Please individually complete that by the end of the day tomorrow by 5 o'clock. Every person individually needs to complete the survey so that we can track attendance, and that's how we verify who was with us. So even if you're attending as a group, each of you individually need to fill out that information. Please do your best to give us accurate mailing addresses and proper name spellings. We will be sending out hundreds of certificates, so it'll take us about a month because we have a very small team and we're doing our best. So please do fill out that survey at the end of the class. Other housekeeping notes, we are recording the session. We will make the recording available. We will put all of the recordings that we're doing under this wonderful MISTA grant on our YouTube page, so you'll be able to find those online. You are muted, your cameras are off, so we cannot see or hear you, but please feel free to reach out using the chat if you need assistance. Please put all questions about the content and training that you'd like answered into the Q&A feature. As you can see, we have lots of wonderful greetings and messages in our chat, which is a lively spot. So we don't want to miss your questions. So please do use those in the Q&A. I'll try to keep an eye on that through the training today, and we'll try to answer any questions at the end as well. If you have a specific situation with a lot of details that need to be shared, please do email us or set up a time to chat. It's much easier for us to answer those kind of tricky situations or maybe situations with a lot of facts. And we often have more questions than answers, at least initially. So please do contact us about that. As I mentioned, you'll have evaluations that will come up in your browser automatically at the end of the webinar, but we'll put the link in the chat. So please be sure to grab that for multiple attendees. And once again, we're really grateful to MISTA to provide this training opportunity to you all at no cost. So thank you so much for logging on to join us. And we do have a couple of housekeeping notes in the chat as well. So as I mentioned, Lindsay is working behind the scenes. I'm Liz Keegan. I'm the Director of Education and Outreach at the Fair Housing Center. This is our contact information. We are on Facebook. We are on LinkedIn. We have an amazing website with tons of resources that we're really excited about. If you haven't visited lately, it's all new with really great searchable platforms for resources. You can filter by language, by topic, by protected class. So make sure you check out our website if you haven't done so already. We also have a trainings page with future events where you can find trainings and register, and we will be hosting a April workshop series as well. So lots of information on our website available for you. So those of you who have attended before, and I see a lot of familiar names, you know we always have a busy agenda and lots to cover, and this level is no exception for our very advanced 301 level class. We're going to put you to work this morning. We have lots of interactive polls. We tried to design the content to help do quick reviews of some things that should be familiar, and then some questions to help think about how do we apply fair housing now that we are more comfortable with it or know more. We also have some new guidance that we'll spend more time on from HUD, and then we have some new protections coming online here in the state of Michigan. I do understand not everyone is logging on from Michigan, so I want to highlight that this is, we'll be talking about source of income protections for the state of Michigan only. We'll look at that new HUD guidance. We'll talk about applications and selection of tenants, and then look at persons with limited English proficiency or LEP, and then some activities and information around occupancy, effective communication for persons with disabilities, modifications, accommodations, and assistance animals as well. So lots to talk about. In case this is your first class with us, welcome. We are the Fair Housing Center of West Michigan. We abbreviate that FHCWM. Our mission is to prevent and eliminate illegal housing discrimination, ensure equal housing opportunity, and promote inclusive communities. We really try to lead with education in order to support the idea of preventing housing discrimination. We do accept complaints of allegations of housing discrimination and work on the enforcement side as well. We're celebrating 45 years this year as a private nonprofit. We have grown significantly from the Fair Housing Center of Greater Grand Rapids in 1980. We cannot provide legal advice. We do not have practicing attorneys on staff. All information provided is for educational purposes only today, and all information is current to the best of our knowledge, but please note that could change at any time. And again, you'll want to stay tuned to our website or sign up for our newsletters to stay up to date on what's happening in fair housing. There are other fair housing centers in Michigan and in some of our neighboring states where I know some of you are logging in. So these are the links to the Michigan Fair Housing Centers. If you're outside of Michigan, you're welcome to contact us and we can try to help find a local fair housing center for you. We are a member of the National Fair Housing Alliance, or NAFA, and so we can help find other resources across the country if need be. This is a map that Mishta put together very kindly. Not only are they sponsoring our training today, but they put together this great map breaking down the coverage of counties in Michigan by the different fair housing centers. Our service area is the teal counties on the west side of Michigan up through the north into the Upper Peninsula, but we often end up doing training in a lot of the orange and blue counties as well. So we're happy to be your first stop, but we'll try to connect you with any local fair housing center that may exist closer to you because they're going to be experts on local fair housing laws and what's happening at that level. Fair housing laws is all about upholding choice within a very busy housing market. Of course, it's been fluctuating a little bit in terms of having record levels of housing needed. People are looking for affordable housing, accessible housing, housing in neighborhoods where they want to live. And so upholding the ability to do so without experiencing illegal discrimination is really critical. It's tied to federal, state, and local fair housing laws. So quick review of what those are. We'll look at those, and we'll also just want to illustrate again that fair housing laws prohibit discrimination, not only in rental housing, which is what we're focusing on today, but sales, home loans, insurance, appraisals, and can even apply to land use and zoning decisions. We're very passionate about our work because where we live directly impacts how we live. So having that freedom of choice is really important. So thank you all so much for taking the time to log in and join us. If you missed a little bit of our housekeeping, we will send out an evaluation link at the end of the class to ask you to complete that to track your attendance. Each individual will need to complete that evaluation survey at the end of the class, and you have until the end of the day tomorrow. You can also contact Lindsay if you haven't received an email with handouts for today's training. You should be able to contact them using the chat feature, but please give them your email so that we can then forward the handouts to you. Okay, our first quiz. We're going to test my ability and your fair housing knowledge here. Zoom keeps changing their settings on me. And so I think I have found the right question here, and it's a bit of a matching element. So hopefully this will work on your end. It's a new feature of Zoom that we thought would be fun to try. Which protected class is covered under which law? So your options for laws are federal law, state law, local law. Your options to match the protected classes are marital status, race, and weight. Give a little bit of time here for you to make your selections. And then we'll share the responses. All of the polls are really just for engagement and not for any sort of credit or completion. If you're watching as a group, you'll have to decide how you want to vote together. About 30 more seconds here. And then hopefully I'll be able to share the results with you. Okay, I'm going to end and share. So the colors are a little close together in my opinion with my vision, but it looks like we had a very strong response that people selected race as the federal protected class, which is true. Marital status, a lot of you got that, and that is the state protected class. And then we do see weight included on a lot of local ordinances. So great job. Let's see if I can. Thank you for doing that. It's kind of a neat little feature. All right, back to, so our list of federal, state and local protections has grown. And again, this is a class focusing on Michigan. So we are happy to help direct you to other resources if you are operating outside of the state. But the United States federal fair housing protections that apply across the country are race, color, meaning skin color, national origin, gender, religion, disability, and family status. Those of you with federal financial assistance, if you're funded, insured, et cetera, by HUD, you are subject to the equal access rules, which also create protections based on marital status, sexual orientation, gender identity, and composition of the family, essentially saying anyone who presents as a family should be treated as a family. State protections here in Michigan, we've had marital status, meaning whether or not somebody is married, and age, with the exception of senior properties. Here in Michigan, we've had these since the 1970s. In 2023, we added a definition of race that was inclusive of hair texture and protective hairstyles under the Crown Act. So that is also a protection. Last year, a year ago, February 2024, we added sexual orientation and gender identity or expression as state protected classes. And we'll be talking about source of income protections, which go into effect here in Michigan in April. So then the list may get a little bit longer depending on where your property is located and if the communities where you are working have local fair housing laws. So here's a couple of resources. If you're outside of the state, you can also use these links and just get rid of the Michigan at the end to look up local fair housing or human relations codes. We're also happy to help with that. But for example, Ann Arbor, Detroit, Grand Rapids, Holland, Jackson, Kalamazoo, Kentwood, Lansing, Traverse City, Wyoming, all have fair housing ordinances at the local level. We have the ones in West Michigan in our service area linked on our website as well, but we're happy to help you find that. I do always spend time on the protected classes because I think it's a really helpful way to get familiar with fair housing and help you practice fair housing in terms of compliance. Knowing who your protections are based on where you're working and how you're funded can help you think about fair housing all year long instead of, just a few times a year. Knowing who's protected, I think, is a really great way to ask yourself, are we keeping up in compliance? Is there any chance we're treating any of these groups differently? It's one of the first questions we ask ourselves too, is who's affected by what we're doing, what we're thinking about, what we're talking about by this policy that we're exploring. And if it's a protected class, you'll want to do some fair housing due diligence. Okay, so in Michigan, here we go. We had a package of bills that were all tie-barred together. You did receive or will receive them if you haven't already, a handout where we put all 5 bills together in one document. So you can see the language. They were signed and they are scheduled to go into effect on April 2nd of 2025. You also have the amended Elliott Larson Civil Rights Act as one of your handouts. That is the bill, the law that has been in place here in Michigan since 1976 and has significantly expanded. They updated the Landlord and Tenant Act as well to make sure the language kind of matched between the two, where we add source of income protections in rental housing only. So the laws define source of income as benefits or subsidy programs that include housing assistance, housing choice vouchers, also used to be called Section 8 vouchers, any type of voucher, public assistance, veterans benefits, Social Security, supplemental security income, or other retirement programs, and income related to any programs administered by federal, state, local, or nonprofit entities. So this is the definition of source of income in terms of the new laws. It does not include income that cannot be shown to be derived from legal activities and sources. So this is something that if you've seen local source of income protections, legal and verifiable income has been a standard at the local level for a while. It also specifies that the income should be ongoing. So it's legal and verifiable and ongoing income. And any agency that is administering housing assistance needs to move forward within 30 days after they are given all the information required that is part of the agency's approval, making sure evidence of repairs and all of that has been completed. So a little bit of a timeline encouraging movement forward here as well. So we're looking specifically at the Elliott Larson sections that have been amended. So there's section 3 here. A landlord of a rental unit shall not, on the basis of source of income. We're going to look at A through J because these are all the prohibited behaviors. So a landlord can't deny or terminate a tenancy, make any distinction, discriminate, or restrict against someone because of their source of income. So that would look like changes in price, terms, conditions, fees, or privileges related to the lease, rental, or occupancy of the unit. It also applies to anything that comes with that unit, any facilities or services that are offered as par for the course of renting that unit. And that's language that has been affiliated with fair housing laws for a long time. Any changes related to a protected class need to be evaluated very carefully, and that is called out here specifically. Person who's a landlord shall not, on the basis of source of income, make unavailable or deny any rental unit who would be otherwise eligible except for where their income is coming from. So if the person otherwise qualifies, they should be considered and shouldn't be denied based on their source of income. It's a violation to represent to a prospective tenant that a rental unit is no longer available or withhold a listing when it is in fact available. It's also a violation to refuse the tenant to inspect a rental unit under the new laws. Similar language again in this section, but it's really focusing on prohibiting differences of treatment based on a prospective or current tenant's use of emergency rental assistance. That should not trigger any difference in treatment for them. As we can see, kind of the same price, terms, conditions, fees, or privileges language. If a person with a landlord does require a certain threshold level of income, which is very common, we all see income base as a requirement, how much income is required to rent a unit. They should not exclude any source of income in the form of a rent voucher or subsidy when making calculations. This subsection specifically doesn't apply to emergency rental assistance. So, vouchers are going to be ongoing. So what this means is you want to use the portion of the rent payment that the applicant or tenant is responsible for in making your calculations. So we'll have a little example of that, but essentially, only applying your income criteria, perhaps you do 2.5 times the monthly rent to the portion that the tenant is responsible for, which is something that some housing providers has been doing for equitable participation in this program for vouchers anyway for some time. And then it's also covering or prohibiting any attempts to discourage the rental or lease of any unit. And then it includes the advertising provisions. So it's a violation to publish, circulate, display, or cause to be put out there any communication, ad, notice, signage of any kind that indicates a preference limit or requirement based on any source of income. So any sort of published ad, any website language that would say no Section 8 or no vouchers, things like that would be a violation based on this subset of the law. And then finally, some protections kind of for both parties. So a staff person could not be coerced into violating this law as part of their job. And then on the flip side, anyone who is trying to exercise their rights or file a complaint under this law is protected from retaliation, which is pretty common, and we'll look at a little bit more in detail there as well. So again, you have the amended Elliott Larson as a handout. You also have the bills as a package into one single document as a handout to refer back to. Our understanding is April 2nd is when these will go into effect. There's a couple of exemptions. So a a landlord or a person taking into account all of their businesses, whether it's an LLC or anything that's related to that individual. If they have fewer than 5 rental units in Michigan, they are exempt from this section of the law under the Tenant Landlord Act. Anybody with 5 or more units is covered and needs to comply. So a couple questions to check on comprehension here. So there may be some questions coming in, but let's do our quiz questions and then I'll try to circle back to some of those. So that means I have to get my poll menu to work again. So we've got 2 questions to kind of think about applications. Which of these scenarios would be a fair housing violation under these upcoming source of income protections? And hopefully you can choose multiple choice there. And then we have a second question. A family with a voucher applies to your property. Your policy is applicants must show income for 3 times the rent. If the rent is $1,600 and the voucher will cover $1,500, how much does the applicant need to make a month to qualify? So a little bit of math this morning. I will say the folks at MISHDA, the folks at the Michigan Department of Civil Rights, and the statewide fair housing centers are all working together to kind of get some clarity and get some legal guidance on what the law will look like in terms of how it's enforced. So some of the questions that you have are good, I can see, and we don't have specific answers yet, but we will be taking those questions to our state partners to get as much information as we can. So keep the questions coming. Public assistance, I think, could include food stamps, but I can certainly try to get some more clarity and more examples on that. There any more specific guidance about the requirement to permit someone to inspect this? So the language that you have is all we have at this time. But I think even if the unit was leased, and there's going to be some turnover, I would think that an inspection would need to occur whether it's occupied or not, but that's something we can look for clarity on. And then the affirmative marketing question is an interesting one as well. We don't have clarity beyond. We have a little bit better history, I think, with federal and laws in terms of affirmative marketing, but I'm going to have to ask about whether or not it would be a good idea to state that it's approved. I feel like it would be because it's factual and it's not stating a preference, but these are great questions and we'll take them back to our partners at the state. So thank you. Let's see, how are we doing? Let's do maybe 15 more seconds. And a question about landlords that state they will take the voucher but will not fill out any paperwork. I think that some of the provisions in the law were written especially to address some of that in terms of encouraging housing agencies to work faster and work together with landlords. I think that would be a violation because essentially they're not participating in the requirements to move the housing transaction forward. But great questions. This is all very new. So let me go ahead and end the poll and share our results. So hopefully you are seeing our first question here. We're looking for which of these do we think would be fair housing violations under these new source of income protections? A voucher holder being charged higher rent, 80% of you chose that one, and I would agree with that. We saw there were differences in pricing was listed several times in the law. Someone with a voucher puts in maintenance and doesn't get the job done, and their neighbor without a voucher does get it addressed quickly. That is also a violation. But if someone, doesn't pass other legal criteria for renting the unit, such as, having some outstanding rent and unpaid damages, that would be somebody that I think would not be qualified. And I appreciate that even though they have a voucher, that doesn't mean they have to be accepted. Exceptions made to all of the criteria that is otherwise applied to tenants and applicants. Second question, a family with a voucher applies. Here's where we're doing our calculations. They're only responsible for $100. Your policy is 3 times the rent, so they would need to verify. 35% of you showed they would need to verify $300. They could cover that 100 every month because they have 300 available. So it's a shift in how we do our income calculations, but it's addressed specifically in the law. So again, it's only the portion the individual would be responsible for, charging the 3 times the rent towards the whole rental amount when only a small portion is coming from that individual is specifically called out as an example of what not to do. Okay, great job on those. And as I said, we are going to be working on getting more information out there. Sign up for our newsletters and stay tuned to our website, follow us on Facebook and LinkedIn. As we learn more and as more resources come available, we'll be sharing those. I know there's fact sheets being worked on and then also frequently asked questions being worked on. So thank you so much for asking some good ones. And you know, we're going to be working on this quite a bit. So please do stay tuned. Good question on the short-term voucher. I think we'd need to know a little bit more about that in terms of how short and what types of lease are offered at the property. So that's one where maybe a little bit more detail would help us assess the fair housing risk. But certainly one of the questions I want to add to our list to have see if we can get some clarity from the folks that'll be enforcing these laws. And then briefly going back to the question, they only need to show 3 times the portion that they would be responsible for. So if the rent is $1,600 and the voucher covers $1,500, that leaves $100. So we kept the math simple. So it would be $300 that they would need to show that they could cover the portion that they solely alone are paying. Okay, we got to switch gears and keep going. I do encourage you to please put the questions in the Q&A because I know I'm going to miss questions in the chat. The chat has been busy and is got a lot of information in it. So switching gears to the HUD guidance update. At the end of April in 2024, HUD issued guidance on the applications of artificial intelligence, focusing on screening for tenants and advertising. So we're going to take a quick look at the advertising and go more into depth into the tenant screening process. One of your handouts is the number 2 document here, the tenant screening process. However, these links will get you to these documents. If you are working in advertising or want to take a look at that one, you've got both of those documents accessible through these handouts. So one of the things that has been kind of bubbling along for the last 10 years or so is how we do a lot of real estate online and how we use technology in so many things, including access to housing, as well as credit and other real estate related transactions. So HUD and the National Fair Housing Alliance and other groups have been working on how to ensure that fair housing is upheld in these automated systems, algorithms, and the use of artificial intelligence or AI. Now, regardless if you do not use third-party tenant screening services, if you, have limited web presence, this is still guidance that you're going to want to take a look at because it addresses rental housing, property management services, single websites, social media. It's encompassing of a lot of housing transactions and is not solely about the digital platform and AI elements. It has a lot of best practices. See page 11, for example. But it does talk about how ads can be targeted and how this does discriminate. We've talked about cases in the past under Facebook and now Meta. They've had to adjust their platform multiple times in order to address algorithms that were found to be discriminatory. And what that means on the ground is that people are consumers who are looking for housing don't get information. It's withheld from them based on the settings used in the computer systems and software, or it's targeting vulnerable consumers for predatory products or services. It can discourage or deter potential consumers from pursuing housing opportunities. It allows for advertising different prices or conditions to consumers. It can also steer home seekers to particular neighborhoods unintentionally. And even there's been situations where it charges advertisers higher amounts to show ads to some consumers, which correlates with the protected classes. So these are all examples of how some of the ad targeting that happens online can violate the Fair Housing Act. I think these examples are really helpful. So an ad that gets targeted to predominantly Black neighborhoods that includes prominent notices of no criminal records and good credit only, while ads in a white neighborhood don't have that comparable language, that's a difference in treatment based on race. Another one would be mortgage ads for men that has detailed information on current rates for mortgages, but ads targeted towards women just says getting a mortgage is easy. So a difference in treatment there as well. So going back to 1968 Fair Housing Law, this is when the Fair Housing Act first passed, as known as the Act, and it includes this statement that we've looked at a lot over the years. It's about advertising and communications. It's very broad. You'll see state law mirrored this in its advertising provisions about source of income, but it's unlawful to make, print, or publish or be a part of any sort of notice, statement, or ad, sale, or rental that has any preference, limit, or discriminates based on any of the protected classes. So kind of building on that long history of this being prohibited. So quick best practice reminders, always describe the property, not the people. It's very hard, especially with our list of growing protected classes, to describe who is the perfect tenant or ideal resident without mentioning some characteristic that is protected. So the most risk-averse strategy is describe the property, not the people. Make sure you understand that advertising includes promotional materials, newspaper ads, internet ads, any verbal statements made. You know, we rely on technology to communicate so much more, voicemails, emails, text messages, platforms where we communicate, all are covered. So when in doubt, take it out. Do not print, do not publish, do not post, and make sure you're using the Equal Housing Opportunity logo or the HUD poster down here in the corner. We do have those in English and Spanish, and we can send those out. HUD does not print them anymore, but we print a version of what they used to provide ourselves. There's a link there to the Equal Housing Opportunity logo where you can download it in different sizes and formats. So the second piece in 2024 was screening of applicants for rental housing, and it does focus on the involvement of third-party screening companies, tenant screening services, but it does include best practices across the board. So again, really important to pay attention to and learn from this latest guidance. Keeping in mind the Fair Housing Act applies to housing decisions regardless of what technology is used. It also includes issues and examples, which I think are really helpful. It's very easy to read, and it suggests how to avoid discriminatory screenings. So it has a couple of components. We'll look at guiding principles, and then there's a second section that looks at additional considerations. So I've kind of summarized the 6 steps here that they have for non-discriminatory screenings. Number 6 is really if you are working with a screening company as an outside third-party vendor. The others, I think, are really informative in terms of best practices for policy and practice. So we will take a look at these one by one. A lot of these are going to be pretty familiar, but it's important to have relevant screening criteria. So you really need to focus and limit what you're looking at to the compliance of tenancy obligations and whether or not the likelihood of them being compliant is there. You want to be precise, waive criteria that's not relevant to the individual circumstances. They actually use the example that we were just talking about, you know, setting a minimum income limit for someone whose rent is paid by the third party is exactly the example and poll that we just took a look at. Here we want to encourage using the minimum income that only the applicant will pay versus the total rent. You want to prioritize recent records. You want to avoid screening incident-free current tenants, and don't use records that don't have a negative outcome. So an eviction where the tenant prevailed should not be used as a point in evaluating them. If it's not clear, which many records are not, you want to disregard it unless you get additional accurate, relevant information. Accurate is key. There's a lot of data sets for tenant screenings that are incomplete. They often miss specific information that helps us know exactly who we're looking at. So there's mistaken identity issues, and it's often very out of date. Records of people with the same or similar names are often attributed to the wrong person. This happens more commonly for Hispanic, Asian, or Black individuals. So really making sure you have accurate information, all the information you're looking at, the multiple pieces are matching and match the individual who is seeking to be housed. So some helpful questions to think about. Where's the data coming from? Is there any data cleanup undertaken? How is that done? How often is that done? So a little bit of due diligence to make sure we're using information that is reflective of the person that we're screening. Follow your policy. We've said this for a long time under fair housing, so this isn't new. But don't ask applicants for any history that falls outside of your policy. So this can help streamline and also limit fair housing risk, which a lot of these principles and best practices do. Don't consider records outside the scope of your stated policy. So if your screening policy is focused on felony convictions, which is a good practice, you don't want to consider any misdemeanor information. If you are using a screening company, they need to be using your standards that you set and conforming to your policy. You don't want to buy a product, so to speak, off the shelf. It really needs to be tailored to all the laws that we talked about that can change based on where you are and your policy that you set. Something that's very consistently emphasized is transparency with applicants. So having tenant screening policies available in writing, available to the public, available to potential applicants is recommended. So it could be done by physical copies, links to a website, but as a regular practice to systematically give applicants the complete detailed information. It's important so they know how they'll be screened, why they were denied. It will help them decide whether to pay a fee if there is one and take the time to apply or not. So helps with the process to be transparent. It's also recommended that you give information on how they can submit mitigating circumstances. You always need to welcome and identify any requests for accommodations on the basis of a disability, and they need to be allowed to contest a record that's inaccurate, incomplete, or irrelevant. So kind of allowing for that back and forth there. Denial letters, it's recommended to have as much detail as possible, especially calling out the standards where the applicant fell short and telling them how. So for example, instead of just saying you were denied because of your credit score, the messaging should be you were denied because we require a credit score of 567 and you have a credit score of 456 according to ABC company. So that way they're empowered with the information. They can go work on that or double check that if they so choose. You want to include all criteria they failed to meet and attach all the records used and referenced. Allowing applicants to challenge negative information, allowing them this opportunity helps with any inaccuracies or disqualifying information that isn't correct. So allowing for this kind of exchange, provide them the information that you used within the specific standards so that they know why they were denied, and that may help them provide additional information. Even if the record is accurate, they should be allowed to show, maybe they've had a change in education or employment status, maybe they've attended a rehabilitation program, a ready to rent program, financial literacy, or again, here's an example with the minimum income standard requirements for a housing choice voucher, where they would recommend focusing only on what the voucher holder's portion would be instead of the entire rental amount. And then the additional considerations are credit history, eviction history, and criminal background screening. So we'll take a look at these three, and then I'll kind of try to circle back and look at some questions because I can see a lot of activity happening, which we love. We knew we would have lots of questions. Credit scores are designed really to focus on whether somebody's going to default on a loan or not pay a loan that they take out. It's not designed with a tenant and rental situation in mind. They don't capture the history of timely rent payments that folks might have, utility payments, other bills. They don't capture information from payday and non-traditional lenders. And it also creates a disparate impact on people of color, persons with disabilities, and survivors of domestic violence. So it's kind of considered an overly broad screening, which may have an unjustified discriminatory effect on these protected groups. So, the question is, what are we trying to get at? We really want to know, are they going to pay their rent? Is there any other way we can get this information? And one alternative is income verification. There's no known studies on the relationship between having a credit score that's high and successful tenancy. Previous HUD guidance has noted that housing providers may forego credit checks as long as they don't discriminate because of a protected characteristic. So there's, I think, been some understanding or maybe a common belief that you have to do this, and HUD has noted that it's not required under their guidance. It's become very common practice, but we really kind of step back here and think, is it giving us information that we need? We want to avoid denials based on credit scores and circumstances where the applicant's financial background has especially little relevance. Now, maybe they do have that voucher, maybe they have a cosigner, Maybe there was a medical or family emergency that has since resolved. Maybe they were a victim of domestic violence. So allowing, again, for that explanation and really verifying that the information being assessed is accurate is important. You may waive a credit history requirement as a reasonable accommodation for a person with a disability, but that has to be evaluated under reasonable accommodation processes, which we'll circle back to in our second hour. So having no credit history or limited credit history is even less relevant than having a poor credit history. If you just don't show up on the credit history screen, what does that mean about you? Admitting applicants, so long as they don't have a negative credit history, may be more precise than requiring a positive credit history, according to the guidance. Automated screening tools can be programmed to rely on other available financial information as a substitute for absent credit scoring as well. So if you are using a third-party system, that should be adjusted. Now on the eviction history component, and this is the most commonly marketed screening component, it's a standard feature. The data comes from private databases from court records. Studies have shown that these records are notably unreliable. A large study found that 22% of eviction records evaluated had ambiguous information, so it was unclear on what happened with the case, or it just was wrong. It falsely represented a tenant's eviction history. And again, there's a disproportionate impact specifically on protected classes here. So again, where a very broad screening standard may have an unjustified discriminatory effect on these protected groups. So recommendations are not to rely on eviction records that are old, incomplete, irrelevant, or where you have a better measure of an applicant's behavior available, maybe just past rental history, recent rental history. Take into account those who have a disability, those who are being retaliated against for exercising their fair housing rights, those with a history of domestic or dating violence or sexual assault. Applicants should get the chance afterwards to have the records disregarded and corrections made once we kind of do this evaluation. Under Fair Credit Reporting Act, tenant screening companies must include the existing disposition information for eviction records. So not denying applicants based on eviction proceedings where they prevailed or a settlement was reached or where it was dropped. So that should not be considered. Discounting no fault evictions where the property was removed from the market is also a recommendation. Important to distinguish between these different types and the different outcomes that they might have. So again, what do we need to know about the eviction to find out if they can be a good tenant now? Why, when, what were the circumstances? What if it was long ago? What if the circumstances no longer apply? So some considerations recommended there. And then criminal records, this is building off 2016 and 2022 guidance from HUD. We'll take a look at that in a moment, but you'll see very common themes if you've been trained on those earlier pieces of guidance. People who have been involved with the criminal justice system are disproportionately individuals with disabilities and Black and brown persons. So again, that unjustified discriminatory effect is hitting those protected classes as well. So any screening reports, any recommendations, any sort of reports that come out of screening from these other outside parties have to make sure they're taking into account and are done in compliance with this HUD guidance. If they have not been keeping up to date, if they haven't updated their processes, that's a group that you really don't want to work with because it's not best practice and they may not be in compliance. So having that conversation with any third-party group is really important as well, and documenting the results of that. Criminal activity shouldn't be taken into account if it was related to an underlying experience of domestic violence. This may be a situation where someone was being forced to write bad checks or the property damage that occurred was during a violent incident. Again, accommodations related to persons with disabilities may be required. This might be exceptions to admissions policies or disregarding certain criminal records. The examples given are that the person's disability might make it unlikely now that they would reoffend, or that their past criminal activity can be shown to be related to a mental health disability that has since been or is under treatment. So it's no longer a factor. And that is a process that's outlined under the joint statements for accommodations. And we could always direct you to that specifically if you're looking for that information. So some best practices: housing providers are liable regardless of using a screening company. The responsibility still comes back on the housing provider and the screening company could be held liable as well. So it's important to have your own policies and practice in place. All denials reflect your own judgment of the policies that you wrote and designed. Your policies should be cleared, detailed, publicly available. Only use services that are implementing your policy, and avoid kind of that off-the-shelf, no customization product, because we've talked about the layers of law. So more information on these is available on pages 8 and 9 of that guidance. If you do get a screening report with a denial, you should make an independent determination under your policy whether the information in the report is in fact disqualifying. So it's best not to rely on that decision from that third party. If it's not disqualifying, you should accept the applicant and consider contacting them to adjust screening standards. It doesn't matter who finds the disqualifying information. Applicants need to be given the same information, same opportunity to exchange that information, dispute accuracy, etc. You're ultimately responsible for ensuring applicants have the full opportunity to do that. In a tenant screening company selection, you should inquire about how they are operating to make sure they are doing this in compliance and using accurate data and have non-discriminatory measures in place. So looking at screening services that can be customized, that frequently update their data, that monitor for discriminatory effect, have clear and specific reasons for denials, allow individuals to correct inaccuracies, publicly disclose key details about their screening systems, and comply with all applicable law. So some helpful things to consider and or revisit if you've had a long-standing relationship and haven't looked at it with this guidance in mind. There is a section that is relevant for tenant screening companies themselves. So that's pages 9 to 10. So I would make sure that they have that information, and they should also be conducting civil rights monitoring to make sure that the products they offer are non-discriminatory. And again, this is where documentation is critical, and making sure your protected classes is being used. So again, they need to be implementing your policies. They should be customizable. They should not offer options that are fair housing concerns, such as unlimited or lifetime look-back periods. They should not provide default standards, or at least set them to the least exclusionary options. They should provide all relevant details that are available, good data sources, use plain language. And any denials or low grades should not be given in a conclusory fashion. So again, the housing provider needs to make the determination in the final decision. And then there's some samples on the back of that document too. So I will circle back to some questions as best I can, but I'm going to go ahead and finish the criminal background section right here. Again, finishing on the screening companies. Sorry, here we go. I moved back, I'm going back in time. These are best practices in the procedural side of HUD's combined criminal history guidance from 2016 and 2022. The second section looks at policy. So this is also in the fact sheet that you received as one of your handouts, as well as all of this kind of summarized. So you'll see how it kind of has been building upon each other through the last 9 years or so. One recommendation HUD has made is, maybe not using criminal history because it's not really effective in telling us if someone will be a good tenant based on some big studies that have been done. State and local laws may limit the ability to run criminal background checks. Same thing with any program requirements. Some funding packages, federal or state, can require certain regulations or restrictions. So you need to know how you're funded and make sure you're operating in compliance with those. Of course, avoiding any third-party screening companies that are using biased algorithms or have been found to use them without updating them is problematic. Having that policy in writing, having it available has been reiterated. One suggestion is to delay considering criminal history until after first verifying financial and other qualifications. We want to treat comparable criminal histories once we have our policy established similarly across the board. Before denial or eviction, giving that information to the person and having that kind of assessment, individualized assessment exchange of information is important. HUD recommends only evicting for criminal activity as a last resort. And after that individualized assessment, don't evict people because they've been victims of a crime. Don't ban tenants' invited guests from visiting based on the guest's criminal involvement. It's direct from the HUD guidance, and of course, documentation of all screening, circumstances, information considered, and any decisions made. You want to maintain that for at least 3 years. In terms of what the policy should address, looking at nature, severity, and recency of criminal conduct, that has not changed. That's been pretty standard. So what was it? How bad was it? How long ago was it? Make sure the policy can be justified with reliable evidence, that it's tied to and focusing on resident safety and property safety. So it's really focusing on criminal conduct, especially convictions, not arrests, that have a demonstrable risk to resident safety and property safety. So differentiating between homicide, sexual assault, and arson versus gambling, prostitution, tax, or cyber crimes. Blanket bans like no felonies, automatic denials, use of arrest records and not conviction records have all been struck down as discriminatory. They can't be defended as non-discriminatory. And again, looking at how long ago or how much time has passed, the look back period. We see very long look back periods, and that is a problem under this guidance. So again, reiterating that need for individualized assessment, considering the circumstances, again, age of the individual, evidence that they've maybe been a good tenant since, maybe they've graduated from a rehabilitation program, maybe they're asking for an accommodation on the basis of disability. So that kind of pause. For properties that are low income housing tax credit or LIHTC properties, refer to the compliance manual, which defers to the HUD handbook. I think this link is out of date, but I can get you a new link, or you can Google this exact language and it'll get to you online. There's pages 4 through 18 and pages 4-18 and 19 outline the background screening criteria. And it sets forth that owners must establish written screening criteria to prohibit the admission of certain individuals, focusing on drug-related criminal behavior, or if they're subject to a state lifetime sex offender registration program, or are individuals whose abuse or pattern of abuse of alcohol interferes with health, safety, and right to peaceful enjoyment. Owners may choose to expand these requirements, but they don't have to. It's a choice. Quick case on retaliation, and then I'll take some questions, I think. HUD is charging a case out of New Hampshire. It's the property manager, the owner, all being charged with retaliation, threatening and interfering with the tenant's fair housing rights. The tenant is a Hispanic male. He's been at the property for years. He's lived there with his minor child. He filed a separate HUD complaint in June of 2023. The respondents are the group above. They submitted their answer the next month to HUD. In November, the tenant was notified that his tenancy was being terminated for material false statements made on his rental application that were recently discovered when a background check was completed. They alleged that he failed to disclose a conviction for a reckless road endangerment charge from 2005 when he was 19. So that was 14 years prior. The respondents filed to evict him. The tenant told his HUD investigator about what was happening and that he felt like this was retaliation by the background check being conducted 4 years after he moved in. So his HUD complaint was amended. They agreed to include the retaliation claim. The respondents said they don't do background checks on residents. However, they did one because of the June complaint to HUD. They told HUD that. They admitted this is retaliation. So it was found to be retaliation under state law and also fair housing law. They also found that he had provided credible testimony that at the time of his application that he disclosed his criminal history. The rental agent told him not to worry about it, and he had evidence of that. So any sort of retaliation like this is protected and prohibited. Couple quick points on some issues that we see or where we identify fair housing risk. So an extensive list of convictions in a policy, many of which are not tied as they should be to property and resident safety. Sometimes we see really broad categories: family relations, government, public peace. Remember, they recommend specificity, be specific, be precise. Vague language is not helpful. May be denied if a felony is evident. That isn't very informative. Not defining the type of crime in the policy, having lifetime or unreasonable look-back periods. There's been several big cases about that, and not offering that opportunity for individualized assessment. So let's see if I can kind of What look back period is recommended? Originally, I was hearing 3 to 7. I've seen it shortened more towards 3 to 5, but it's kind of based on some case law. I don't have anything necessarily specific, but that's kind of the general direction that I've seen it go to. So that's a good question. For HUD housing, they have to follow their specific policies. The 2016 and 2022 guidance is for the general fair housing market. Unless you're a PHA, then you need to follow the 2015 guidance, which I think we have. Oh, no, sorry, we don't have that. We looked at that in the last training. So you have to defer to the right guidance based on how you're funded, and we can help with that. But the 2016 and 2022 guidance, 2024 guidance that we're looking at doesn't call out that population specifically. Let's see. Okay, and then we're circling back to some source of income. Okay, so I will circle back to those. We want to do a quick poll here, kind of testing our knowledge of screening policies using this sample policy. So we have ABC Apartments. They adhere to a strict criminal background policy. We are looking for aspects that are listed below, options that are listed below that you would consider have a fair housing risk or would be a fair housing concern. So a little chance to think this through. All 18 plus applicants, 18 years or older applicants must pass a background check. Applicants with these criminal backgrounds will be denied. Any felony convictions in the last 10 years, felony convictions related to property offenses, major drug offenses, fraud offenses, major violent offenses against persons, and sex offenses, arrests for felonies that have pled down to misdemeanors or currently on parole or probation. So your choices are that they have a strict criminal background policy, that everyone 18 and older must pass a background check. Any felony convictions in the last 10 years is another option. Felony convictions related to property offenses, arrests for felonies that have pled down to misdemeanors, or if they are currently on parole or probation. Which do you feel, and you can choose multiple, would have any fair housing risk or concern? Maybe 30 more seconds. I'm trying to multitask here. Okay. Let us end and share. So is it okay that they have a strict criminal background policy that they adhere to? Yes, I don't think that's a risk. All 18 and over applicants must pass a background check. If that's applied universally, I don't think that's a risk. Screening for felony convictions in the last 10 years is higher. I just kind of gave, I'm talking about 3 to 5 years, 3 to 7 years. That is much longer time frame, and I think that would create some risks. Felony convictions related to property offenses likely are going to be okay if it can be tied to resident and property safety as a standard. Um, Arrests for felonies that have pled down to misdemeanors, I think would be problematic. And because remember, we're focusing on convictions. That's really what the guidance leans on, accurate convictions. And so if they're currently on parole or probation, that could be problematic as well. So highlighting 10 years, misdemeanors, and parole and probation, probably not in compliance. So I know it's hard to do quick like this, but I appreciate you taking in the policy and kind of thinking about how do we apply it. It's I think helpful to think that through together. Okay, so quickly looking at applications, and then I think we'll take a short break. What information is necessary at what point? Focus on making sure your applications are only collecting information that you need. It's objective information, and it's really focusing on whether they qualify for the housing opportunity. Don't ask any unlawful questions. So as we've continued to add protected classes, it's a good idea to do a review of all of your language, pretty much everywhere. We're doing it here as well, making sure information about protected classes is up to date, removing any standards that are no longer recommended as best practices. Once you have any information about somebody, whether you use it or not, you would have to show that you didn't use it, that it didn't influence your decision making. So it's really important to streamline your applications and information you're collecting from potential residents to really focus on what you can ask for and should be asking for, and get rid of any questions that you don't need to be asking or create a fair housing risk. In terms of disability, there is a prohibition from Congress on blanket inquiries by a landlord, so you can't ask overbroad questions as to the description, nature, or severity of the disability. Can't ask them to waive rights to confidentiality concerning their medical condition or history. So sometimes I do get questions of, can we ask about, do they have an assistance animal on the application? That is something that we would not recommend as the best practice. People, once they make an accommodation or modification request, you shift into a limited space where you can ask questions, but generally you never inquire about a disability, the nature of it, the severity of it in your day-to-day practice. Quick question again, looking at my Zoom menus here are moving a little slowly. Looking at applications. Okay, we're thinking about identification here. Let me launch this. It's a long list, so you might have to scroll down to get to the end. It should be multiple choice. What types of identification can be used instead of a social security number? What do you think? Are any of these viable options? Let's do 10 more seconds. Be quick. And again, don't worry if you don't fill out the polls in time. You're not part of any sort of grading or anything. All right. So we had a mixed variety of acceptance here. I think strongly people were 73% said yes, we would take a passport. Citizenship cards and consulate cards were high. Federally recognized tribal issued photo ID, also high. State identification, driver's license, etc. Well, every one of these is a type of identification that can be used instead of a social security number. We're going to talk more about this. and a case that will help us learn more. So this is a case out of New York. The Zunigas found an apartment. They met the income and credit requirements. Their application was denied because the housing provider strictly enforced a policy requiring that all adult residents have a social security number. Ernesto had one, and Karina was working on hers. She was lawfully present in the country. A HUD complaint was filed, and the conciliation agreement resulted in monetary relief for the Zunigas, along with policy changes. The housing provider got agreed to accept a wide range of documents like we just looked at for identity verification. This is actually a sample policy attached to the settlement of this case. And so some of the ones that we looked at were included on our quiz question, but this really rounds out a lot more. So unexpired temporary resident cards, employment authorizations, reentry, refugee travel documents, etc. So any sort of system that is really limited or tied to Social Security number requirements without kind of opening it up a little bit more does have fair housing risk related to national origin protections. If you want this sample policy or the case, we can send that to you directly. So having overly burdensome documentation requirements for ID can have a disparate impact on people born outside of the United States who have lawful permission to reside here. And statistically, that's most likely to be Hispanic or Latino folks. So the policy should be evaluated with the protected classes in mind. And the question always of, who is being left out, who would be impacted by these types of restrictions. So common issues or fair housing risk is an outdated list of applicable fair housing protections that we see, outdated plans in terms of tenant selection being posted or given out, or it's not aligned with what is actually being done in practice for tenant selection and or screening. Having incorrect or more narrow definitions that don't align with how fair housing laws define a protected class. So persons with disabilities is very broadly defined. Families with children, it's very broadly defined. So anything that's more narrow than that or limits that within those populations will be a violation. Having unreasonable, outdated, or blanket occupancy standards, we'll talk more about that, that don't take into account the actual housing layout, size, et cetera, would be problematic. And then just having plans or criteria that's not easy to use, that's not readable, easy to understand, or very clear are all problematic here. Some best practices on focusing on tenant selection, making sure you're including all the criteria in your policy that is used. Be specific, we've talked about that. It should be written and accessible, we've talked about that. Appeals processes should be made available, and it should be made clear on how folks can do it. And also the right of applicants with disabilities to make an accommodation request to the policy should be communicated. And it's a good idea to include non-discrimination statements as well. Okay. So other best practices, you want to refer to your list of protections that cover the property area. Here's a couple of questions to kind of help you think through what we've been doing. How would an applicant or resident treatment vary by protected class? Is there any adverse treatment or unintentional barriers created? Who's left out? Could you defend any findings as non-discriminatory? Do you have a business justification that pushes back against collecting that information or having that standard or criteria? Very careful assessment needs to be made of that. And then what evidence would you have to show that discrimination did not occur? That's always a best practice to think about in terms of thinking things through, playing devil's advocate, pretending you're having a conversation with a civil rights investigator at the state to say, this is what I do and this is how it's not discriminatory. Doing that on the front end, I think, is very helpful versus having to do it in response to a complaint. Okay, it's 10:08 on my phone, so let's take 5 minutes and be back at, what does that make it? 10:13. Okay, if you could make your way back to your screens and or your seats, I would appreciate it. It is just about 10:13 on my clock, so I want to keep us going. We have more activities and a couple more topics to focus on. So we are switching gears to look at limited English proficiency. This is the Michigan LEP population by language. As you can see, we have a very diverse list of languages spoken across our state, and want to focus on how that may impact or be connected with fair housing protections. So starting with a look at a discriminatory policy case out of New York. This was a client working with a rescue mission that was seeking housing at Swiss Village Apartments. The client and her caseworker were searching for units. The client's primary language is Spanish. The caseworker took over a call after the client had trouble speaking with the rental agent. The agent asked whether the client would have an English-speaking individual living there with the client, and the caseworker said they would not. The agent told him his client would need to live with someone who speaks English in order to rent an apartment at this place. The caseworker was trying to make this work and said he would be available to assist with translation or interpretation as needed, but the rental agent stood firm and ended the call. A local fair housing agency was contacted and got involved to conduct testing and investigations and found evidence that the policy would be applied to any potential resident who did not speak English. So a lawsuit was filed about a violation of the Federal Fair Housing Act on this policy against LEP persons. It was filed in November of 2021. The latest update we've been found is that the respondent, Swiss Village, requested a dismissal, saying that LEP is not a protection, but that was denied. And we'll look at some of the guidance that establishes that as a protected element. So beginning in 2000, there was an executive order issued. This was really focusing on federal agencies needing to examine their services to evaluate access for persons with LEP and making sure that they worked to provide meaningful access to them. Meaningful access is an important phrase. It also requires that any federal agencies that work with recipients of federal financial assistance ensure that access happens to those applicants and beneficiaries. So any receipt of those federal funds triggers coverage. There's a really helpful DOJ policy guidance document that's linked here on national origin discrimination that kind of helps with navigating some of the questions that you may need to ask yourself, whether you are federally financial assisted or not. I think it's always helpful to defer to HUD and Department of Justice guidance as a starting point, even if you are in the private housing market. So it asks some questions and it offers some standards to assess what do we need to do, what are best practices, and how can we establish this meaningful access for LEP persons. So I encourage you to check that out. In 2007, again, this is a regulation focusing on programs receiving federal funds, and it establishes that connection or a nexus between national origin, which is a protected class, and lack of English proficiency. It shows that this can restrict access to housing based on national origin, race, or other protections, even when the housing provider doesn't intend to discriminate. And the courts have recognized that primary language skill generally flows from one's national origin, and that persons of different nationalities are going to often be distinguished by a foreign language. So this is some of the legal basis in the beginning of some of the connections. So again, the 2007 guidance focuses on federal funding recipients and meaningful access. It's all programs and activities that receive those dollars and anyone who's a sub-recipient of those federal funds. So important to know if you fall into this category, do that homework. Because HUD has said they don't do the determination of who is LEP, the recipients of the dollars need to do that work. And LEP persons are defined as persons who, as a result of national origin, don't speak English as their primary language and who have a limited ability to speak, read, write, or understand English. It is possible to be a U.S. citizen and have limited English proficiency. The opposite is also true. You can be fluent English speaker and not be a U.S. citizen. In terms of compliance, asking all beneficiaries, again, for federally financially assisted programs to determine the language they feel comfortable speaking and understanding. There's a variety of I speak cards. That's something that people can point to and identify which language so that you know what language they're speaking and what resources you may need to find. There's no safe harbor for oral interpretation. It may need to be made available in some form, timely and free of charge for programs that fall under this federally financially assisted guidance. If you don't, I encourage you to follow these as best practices, because in 2016, additional guidance from HUD came out that is not limited to only those with federal financial assistance. It addresses how the Fair Housing Act would apply to claims of housing discrimination by this population. Again, not a protected class specifically, but it's closely tied with national origin, which is closely linked to our ability to communicate proficiently in English. Housing providers are therefore prohibited from using LEP selectively or as an excuse for intentional discrimination in housing. It's also prohibiting any behaviors that would impact this group in an unjustified discriminatory effect manner. So let's look at some examples. Suspect practices under this guidance would be blanket statements that all tenants must speak English, turning away all applicants who are not fluent in English. If there is a free or low-cost translation option available, any cost-based justification for refusing LEP population would be suspect. Bans on people speaking languages other than English or disparaging tenants or residents for speaking non-English languages cannot be justified. These are suspect practices in all housing under this HUD guidance. Examples they give of intentional discrimination based on national origin. So landlord refusing to work with persons who speak a certain language, but working with others who speak different languages, not that first one, but anything else. Treating someone differently because they have an accent when they speak English, targeting individuals for unfair or illegal housing related services, kind of flipping that and finding this population to take advantage of them would be likely intentional and would be a violation. So violations occur when policies or practices have an unjustified discriminatory effect, even if you don't mean to or intend to discriminate. So any policy or practice that restricts access to housing on this basis has a discriminatory effect based on national origin, race, or other protections. If there isn't if it's not necessary to serve a substantial, legitimate, non-discriminatory interest, and if there's a less discriminatory way to do it. So this is kind of a test of, what are we doing this for? Is it substantially legitimate? Is there a substantial interest in doing it? Is it a legitimate interest? And is it non-discriminatory? Is there a less discriminatory way we could do this? So always helpful to look at examples to interpret what's meant by this. Allowing a tenant or any other home seeker a reasonable amount of time to take a copy of a document, have it inspected by legal counsel or reviewed by a third party or translated would be a less discriminatory alternative than just stopping working with this population or person. Translating and interpretation services, obtaining written or oral translation services, or drawing upon the language skills of staff members, community member volunteers, making sure you look for trusted professional sources as well. Third-party assistance, if the LEP person has a member of the family who speaks English to a high degree of competency or brings someone with them to interpret, agreeing to communicate through these individuals could be an alternative to just flat out refusing to deal with anyone who does not speak English. So opportunities to work with this population, again, have that time allowed to have documents translated. It's helpful for people to really understand what they're agreeing to, benefits both parties, that there's clear understanding and communication. If you see enough need, you could have certain documents translated yourself. You want to have research already done to know what services are available to obtain written or oral translation services. For example, we use the Hispanic Center of West Michigan. We also use Voices for Health, who is not limited to healthcare interpretation and translation in spite of their name. You could draw upon the language skills of staff members. You could allow LEP persons to have those family members to interpret and agree to communicate through those persons. You can use technology, download apps. Google Translate is not perfect, but there's lots of now options for people to access. There's also an extensive lep.gov resource page, and then HUD has a separate LEP resource page linked here. This image is an example of a language identification flashcard where somebody could point to one of those, and we would look as English speakers on the right to find out what language they would want to be communicating in. I'm going to move on to occupancy and circle back to questions because we do have a couple things that I want to make sure we cover. If you joined us for the 201, you've looked at this, but we want to spend just a couple more minutes here and take an example that's a little more complicated. Occupancy limits should be based on any local health and safety, property maintenance codes. In absence of one, you could utilize the International Property Maintenance Code, or IPMC. This is a screenshot of the 2021 IPMC that talks about how many people can live safely together. Under fair housing laws, this is a common issue under familial status protections, where housing is limited to the number of people that is lower than what, for example, IPMC would allow for. And that has an impact on housing access for persons, families with children seeking to live together. So we looked at this example in our last session, but I'm going to have you make the selection and determination. Let's see, where can I get my, okay. So let me get my, I'm going to launch my poll, but we're looking at 2 bedrooms here. So we've got 2 allowable occupants in bedroom number 1, 3 allowable occupants in bedroom number 2. Looking at the dining room square footage, 3 to 5 allowable occupants using the IPMC, that orange chart. And the living room is large enough for 6 or more allowable occupants. So testing your memory if you joined us last time, what do you think is the proper, sorry, this takes a second to get to now under Zoom, proper determination of occupancy limit? 2, 3, 4, 5, 6, or 7? So remember, this is a 2-bedroom unit. I'm going to go back to the image so you can see how big this layout is. Got 2 full bedrooms, full kitchen, full dining room, full living room. Jump us back here to our question. Give you about 10 more seconds. And share the results here with everybody. So we had a real diverse mix of responses. And in this situation, we recommend a determination of 5 occupants, which 28% of you got. A few of you went higher, a few of you went lower, but this is our, sorry, let me get this up my way. This is our, oh goodness. Now I can't get it out of my way. This is our determination, our explanation. Let me see if I can, my apologies, I've got a issue now freezing with Zoom here. Our occupancy here is we're focusing on the bedrooms, 3 in one, 2 in another. While there is an extra large living room space, the dining room space is only up to 5 occupants. So hopefully that makes sense. We're going to take another look here. I'm going to see if I can get rid of this. My apologies. It is not letting me navigate out of here. I'm going to drop out really briefly here. Oh goodness, I'm so sorry. This is very frustrating. I am not sure if this is blocking your view like it is blocking mine. Okay, thank you. All right, so I'm kind of flying a little bit. Lindsay, if you wouldn't mind launching the polls, if you could, I'm not going to be able to operate those. So this is our second example. We have a bedroom here, 1 bedroom. We have a combined living room and dining room, so this is a little bit harder. So we're looking at the math here, doing the calculations. Let's see, I'm gonna have to pull up a secondary. There we go. So we've got 160 square feet, 3 allowable occupants in the bedroom, looking at the combined living room, dining room, 6 or more allowable occupants. So I'm not sure if we can launch the options here or not. Oh, there we go. Ah, there we go. I am launching. So sorry. Technology is so much fun. Okay. So this is a slightly more nuanced bedroom layout. It is a 1 bedroom. And we'll look back at our layout here. Get rid of that so that doesn't happen again. Bedroom is 3, combined living room, dining room is 6. And this is the image. I'll give you maybe another 15 seconds. We want to move forward here. And this one we have a lot more agreement on. Okay, I'm going to end and share. So majority of folks said 3 people, and we would agree with that. While the living room and dining room is large enough to accommodate 6 or more, there's only sufficient sleeping area for 3 occupants. So that's a little bit of a larger bedroom. So important to take that into account, important to do the work, do the math. We provided you with our step-by-step occupancy calculation guide. It focuses on Kent County in Michigan, but you can use it anywhere because the steps for doing this and the best practices are all the same. Okay, we're jumping over to effective communication. This is a case focusing on American Sign Language interpretation out of California. 30 senior housing facilities conciliated with the California Civil Rights Department just last fall. There was part of a project that was conducted with testing, asking about ASL interpretation or American Sign Language interpretation for seniors with disabilities. Testers were calling on behalf of fictional relatives. The terms of the settlement included new policies, modifying existing policies, and really focusing on upholding the rights of hearing impaired and deaf applicants and tenants in the facilities. This is a second case at this level that I've seen, multiple properties, over $100,000 settlement. It's something that I think people aren't familiar with, and so we wanted to spend a little bit of time here focusing on it, and I hopefully will successfully launch another poll question here. I'm curious to find out, what do you think? What is the best way to communicate with someone who is deaf? You can choose from any of the options listed here. Okay, 10 more seconds. Alrighty, I'm going to end and share. So our top option, 88% said we want to use the communication method based on how the person requests to communicate with us. And that is absolutely a best practice. These other options, if they identify they want to communicate by whiteboard or texting, they have that made that offer, they've communicated that's what they need, that's what works best, then that's what you would want to do. Speaking more loudly, you don't need to do that unless they request that. And I would exercise caution in requiring them to bring someone with them. If they do bring someone with them, of course, you can communicate with them, but any requirement to put the burden on them could be problematic. So we'll look at this in a little bit more detail here. You treat this as a reasonable accommodation, so you want to follow that joint statement guidance. We have guidebooks on all of that. Follow the lead of the person making the request. A request for ASL interpretation for an in-person service should be evaluated when requested. Someone is asking for ASL interpretation for a tour, completing an application together, signing a lease, etc. It's important to know how to call and arrange an interpreter, so having that that information up front is helpful. We work with deaf and hard of hearing here in West Michigan. There's disability networks across the state you can contact to see what resources are available, but doing that proactively and having that information ready is always a good idea. You only have to do this when it is requested and evaluate whether or not it's reasonable on a case-by-case basis. If the first option or the request, is delayed or there's timing concerns, you have to continue to work together to offer alternatives to find a way to effectively communicate housing information to the individual. So it's really a responsibility to recognize these requests, be prepared as best you can, and continue working together to establish effective communication. Video relay interpreting, VRI, may be a good option if it's quick or it's unexpected, but you have to acknowledge that not every solution or tool is going to work for every individual. So that's why it needs to be open. We want to follow the lead of the person making the request. Note that people who are deaf or hard of hearing themselves can use a 711 service. Others who are not deaf or hard of hearing cannot use that service. Other options include TTY or using a TRS operator. We have more information available about this, but some other best practices, in communication, keep your line of sight free for information and visuals. Make sure you're looking at the person you're communicating with, not the interpreter. Use clear language, I and you. Avoid third-party phrases such as telling the interpreter to ask the applicant for information. Don't speak louder, don't shout. If they ask you to speak louder, of course you can do that, but follow their lead, speak at a reasonable pace, allow time for everyone to absorb and receive the information. And again, here's some of the resources. These links are all on the handouts, which you should have. Okay, another poll question focusing on disability-based rights. Get my menu to pop up here. My Zoom window, there we go. So we have a question here. Thinking about accommodations and modifications for persons with disabilities, which of the following statements is false? You must choose one. And we'll allow for about 30 seconds here, so. So we have a few options here. We have to choose one false statement. Tenant can request an accommodation or modification at any time. Tenants with unobservable disabilities or unobservable disability-related needs can be asked for supporting documentation. Tenants can only request one accommodation or modification, or tenant's request must not be unreasonable. Which of these is false? I'll give you a few more seconds here. Okay, a little bit trickier, I would think, having to limit our choices to one. We've been doing multiple choice. We're getting harder here. So what is false? Tenants can only request one accommodation or modification. 71% of you said that's false, and I agree. People can ask for multiple accommodations or modifications. Requests must be reasonable. If it is an unobservable disability or disability-based need, you may ask for supporting documentation. And of course, oh, sorry, we have duplications here. They can request accommodations at any time, modifications at any time. That is true. So you can have somebody who's been living there for 5 years, ask for an accommodation. Somebody who moved in last week could ask for an accommodation. It depends. Okay, so modifications. These are the structural changes like grab bars or ramps. They allow for access and for someone to have full enjoyment of the property, which is a key element of equal opportunity. So these are often things that you can reach out and touch in terms of structural changes. So communication for modifications and follow through is really key. It's not reasonable to deny a request because it will impact the landscape or it won't look nice, it won't match aesthetically. Those are not feasible reasons to deny a request. You can require it to be built in a workmanlike manner. It does need to be done in compliance with local code. We don't want ramps that are too steep or not sturdy, for example. Alternatives must be considered if the initial request is not reasonable or possible. So just a reminder, we looked at this more in the 201. So now we want to think about how do we apply our knowledge? Now we have a yes or no. Is this a fair housing issue? You have an 80-year-old man who tells you he needs sturdy grab bars in his bathroom and shower, but the manager only wants to allow grab bars attached by suction cups. Is that a fair housing issue? Whoops. Let me actually turn it on for you. What do we think? Okay, we'll do about 10 more seconds here. Okay. We had a lot of agreement on this one. Is this a fair housing issue? 90% said yes, and I agree. This is a fair housing issue. Suction cup grab bars are not sturdy. And we're going to learn a little bit more, or we discussed this case actually in the 201 class. So this was a situation of across the state here in Michigan. The specific needs for this gentleman required, based on his disability and the symptoms and management of the disability, that he had very sturdy grab bars. And suction cup grab bars were not going to meet his needs. So that was a case that was filed. Here is a situation where you receive a request, get this going too, for a reasonable modification for a ramp from a resident who has started to use a wheelchair. Check all that apply. This is multiple choice. So this is a current resident using a wheelchair. Meet with the resident to learn more about their request. Ask for a letter verifying that he has a disability and disability-related need. Review the space and local code to see if a ramp will fit. Suggest that he move to an apartment complex down the road because this one no longer meets his needs. We are looking for some best practices when you receive a request for a ramp as a reasonable modification from a resident starting to use a wheelchair. We've got a question about what is a period of time considered reasonable to accommodate? And that is a great question. And I think it's going to depend on the unique circumstances. And I think staying in touch with someone is really important. If you're ordering building supplies or equipment, if there's a back order, if we receive parts that are not what we needed or what we ordered, that is all information that you want to share with the person making the request. So that they know that the work is being done and the request is being handled as best you can. So I've seen situations where people have waited 6 months and the courts have come down very hard. That is not a reasonable amount of time. So you want to be moving as quick as you can, and also staying in communication so the person knows that the request is being considered and work is being done. So it does depend on what's being requested and what needs to be done in response to it. But I think making, weekly progress would be really important unless you had some real hardship. Great question. Okay, we're going to end our poll, take a look at sharing our results here. Best practices, meet with the resident to learn more about their request. I think that would potentially be reasonable. We need to know which door it would need to be built at, where would the ramp work best for the individual, what do they need in terms of what type of ramp, etc. Review the space now that you know it and look at local code to see if a ramp will fit. I think that is very important as well. 93% and 87% selected those. Asking for a letter is going to depend, especially if you have observed this individual using the wheelchair. I don't think that that's necessary to have verification from a third party. We have disability-based knowledge about this individual, and this request can be inferred from the fact that they're relying on this adaptive equipment. So I would not recommend that, and I certainly would not recommend that they move out. So great job. Thank you. All right, quick case review here. This is a case out of Michigan that I was mentioning. This was a 5-year struggle, so not a reasonable response time. A lot of back and forth, a lot of advocacy from Mr. Black. Daniel Black is a man with dwarfism. He settled an apartment complex lawsuit after a lot of hard work and advocacy. This is a federally subsidized property, so they are required under Section 504 to treat accommodations and modifications as more of their responsibility. He wanted a roll-in shower to accommodate his disability. He requested that the bathtub be replaced. It was getting increasingly dangerous for him to use. This is part of an awareness campaign that Mr. Black kindly agreed to participate in. He also wanted accessible electric entrances at the doors so that he and other seniors and persons with disabilities could come and go without assistance. This was a property designated for people with disabilities and older adults. And so would have been a huge benefit for not just Mr. Black, but everyone living there. The size of his tub was 16 inches tall on the side. His inseam is only 17 inches. So he was literally kind of throwing himself over that wall to get in, and caused further harm to his health in having to do that. The housing provider claimed a roll-in shower would cause structural damage, but never provided any documentation of that. They never engaged in the interactive process, which is a best practice where you exchange that information, meet and work together. They never offered an alternative, which is required. Once the Fair Housing Center was involved, the city inspector verified that no structural damage would occur, as did 2 outside contractors. So there was a lot of evidence pushing back on that. He couldn't get responses after a while, so he did work with the local Fair Housing Center. He chose to work with a cooperating attorney. Each request was delayed and denied even after those folks got involved. And as he said, he was tired of contorting himself to get in. It was dangerous. It caused further damage to his spine that also limited his mobility even further, just trying to bathe. He felt like he wasn't asking for anything unreasonable. He wanted what everyone else had, access to bathing and showering facilities. So a case was filed in federal district court. They threatened him with eviction. So remember, retaliation like that is prohibited. Eventually, the shower was installed, and so were the electronic entrance doors, and the lawsuit settled for an undisclosed amount. So accommodations, these are the changes in rules, policies, procedures, or services if necessary for someone to have equal access and enjoyment of housing. Accommodations are largely going to be the responsibility of the housing professional, because they're your rules, policies, procedures, or services. So hopefully that's helpful to understand. This is a quick example of a live-in aid case and request for a key to a unit for the live-in aid out of California. This was a settlement reached through HUD. Where the tenant requesting to have a live-in aid and a second key to a locked gate by her unit was initially denied. They asked intrusive questions. They challenged whether she actually had a disability or not. They asserted the development was only for individuals who could live independently, and they denied her requests. So all of those are kind of textbook what not to do in response to an accommodation request. They denied it having discriminated against them, but did enter into the conciliation agreement. There was some monetary relief. They got the key and also kept the gate unlocked, which allowed the resident to have the living caregiver. They got training and new policies as well. Louisiana Fair Housing Action Center settled a federal lawsuit. This was a request for a transfer. This was a big settlement, $205,000. This was a request from a resident to move to a first floor unit after surgery left her requiring the use of a wheelchair. Her apartment was on the second floor, and there were only stairs there. She made multiple requests over the course of a year, which were all denied. This left her crawling down the stairs or calling 911 anytime she wanted to take her trash out, get her mail, drop off the rent, go to church, leave home, do anything that we all do. Fire district responded to over 100 calls to her apartment, and the fire chief was imploring the staff at the apartment complex to move her to the first floor. Her requests were responded to by placing her at the bottom of the wait list, even though there was one ground floor unit vacant at the time. So only after a lawsuit was filed did they offer the ground floor unit. This settlement ensures that people with disabilities are now prioritized for units that are designed to meet ADA standards. This is specific to this property in this situation, but they also own other properties. So hopefully that will open up housing opportunity in Louisiana there as well. So thinking about accommodations and documentation, let's look at what documentation is needed. You have a new resident asking for their rental due date to be changed to after the first of the month and to not have to pay monthly late fees because their disability income arrives in the middle of the month. As an accommodation, they're asking you to change your rental due date policy. And what's your next step? What should we do? What documentation is needed? They are on disability income. They are a new resident. They live on the property. So our choices are they need to provide information on their disability. They need to provide information on their disability related need. They need to provide information on both, or they don't need to provide info either on their disability or their disability related need. So we'll do about 20 more seconds here. Keeping an eye on the clock. Assistance animals are next, and I know we have questions. Okay, end the poll and share. This was a very close race, I suppose I can say. We know they are on disability income, so we know they are a person with a disability. So 42% of you said they don't need to provide disability verification or disability related need. The disability income arrives in the middle of the month. Our due date is the first, and so we know what the need is, and we know that they're a person with a disability. So I would agree that we would not need documentation in this case. Great job there. Now we have another question. What would you do? What should you do? Multiple choice. A person with a heart condition requests a reserved parking spot due to not being able to walk long distances. We have options here. Request documentation from a healthcare provider. Tell them they can use the existing handicap spot outside the unit. Have them pay for the materials to put up a sign for a reserved spot. Meet with them to discuss the request. Okay, I'm going to end and share. What do? We have someone with a heart condition who wants a reserved parking spot. I would advise against telling them they can use an existing handicap spot because that is essentially something that was already there and is not reserved. It may become reserved for them if it's not needed to have the base number of accessible spaces that are required if there's an office on the premise, for example. But generally, best practice is to work with the individual to choose the spot that meets their needs and reserve it for their individual review, individual use. So meeting with them could be beneficial. If you can't observe or have no knowledge of a disability, you could request documentation. Heart conditions sometimes have outward manifestation. Maybe they use oxygen, but sometimes it's an invisible disability. So those unique facts matter. I would not ever have them pay for an accommodation. So encourage the no fees or financial costs for something like that. Okay. Moving to assistance animals, and I'm already getting some questions, so I'm going to try to do this very quickly. We've talked about them in our trainings before. There's HUD guidance in 2020 that walks you through the types of questions that you can ask and helps assess with these types of requests for living with assistance animals in housing. It encourages you to use information about disability that you might already have. It might be helpful to have a consistently maintained list of animals that are granted permission to be there. Here's a time limit for assistance animal requests. Generally 10 days is considered reasonable for response once all the information is received. You cannot treat assistance animals like pets. Any pet policies that you have should not be applied to assistance animals. We have a separate assistance animal policy you can look at. You can charge for damages if it's the usual practice to do so. So check out our resource guide on that. And we have a true or false set of questions. So true or false, a tenant or applicant is only allowed one emotional support animal. Number two, a housing provider can deny an assistance animal due to their home insurance policy having a breed restriction, true or false. A housing provider cannot require a tenant to get renter's insurance if they have an assistance animal. A tenant is not required to pay any fees on the front end for an assistance animal, true or false. We're going to go through these as well with additional information. So I'm going to give you a few seconds here to answer, and then we'll start scrolling through. We've got kind of FAQs on assistance animals to look at briefly before we wrap up. Okay. I'm going to leave this open, but we are going to jump forward to the explanation. So feel free to keep voting if you have not finished. So what if somebody asks for more than one assistance animal? There is no limit in HUD's guidance, which is the most current guidance about assistance animals in housing. So it is still the default to help us process these requests. It does acknowledge that people can have a need for and substantiate the need for more than one animal. So when multiple animals are being requested, we encourage the requester be educated and then that they be asked to substantiate the need for more than one animal. You know, what does each support animal do to meet a disability-related need or needs? Perhaps the different animals do different unrelated tasks. You know, maybe dog A is the one that gets the person up and outside and leaving the unit and walking, and maybe dog B is the one that provides the emotional support. You can check for local limits under local government to see if there's any limits for the number of animal allowed in the community. That's something that they would then need to go, the tenant would need to go to the local government and ask for an exemption to the animal limit, because local government also has to accommodate disabilities. But asking for multiple animals is not an automatic no. Again and again, we say the unique facts matter. We have to take these into account and evaluate each request on a case-by-case basis. So they can be asked to substantiate the need for more than one assistance animal and provide a little detail on how those are necessary. Okay, I'm going to end the poll. A lot of you said yes, false. You knew that one animal was not a limit. Our second question, 74% said false. Housing provider can deny an assistance animal due to home insurance policies having a breed restriction. That is correct. That is false. Insurance is not a basis that can be used to deny an assistance animal, even if they do prohibit certain breed sizes or numbers of animals. We've been doing our due diligence to educate insurance carriers to help them understand that assistance animals are not pet and that these are federal protections. One step that could be taken is if the carrier would cancel or substantially increase costs or change the policy terms, this may be considered an undue financial and administrative burden. But that would have to be verified, and you would have to show that you've done all of that work. So we're always happy to try to do that education. So you can contact us to assist. Make sure you maintain all that documentation, but generally that is not a best practice to deny on that basis. Can I require the owner to get pet or animal insurance? You may not require persons with disabilities to pay extra fees or deposits as a condition of receiving the reasonable accommodation. So if this is not something you require, it would be new, not something that you can require that specific person. Any extra fees, deposits, or costs applied to any accommodation needed because of a disability is likely going to be prohibited by fair housing guidance. What if I require renter's insurance? This was a little bit more of a split. 64 said true, 36 said false. If your standard policy is for all tenants to have renter's insurance, then there is no fair housing risk, but you can't single out persons with disabilities to implement these insurance requirements. Same thing if somebody installs a ramp, you can't require insurance as a condition of that request. That's explicitly prohibited in those joint statements. Keeping an eye on the clock here. Can I charge for cleaning fees? It depends. Is this something that you do automatically as a regular course of business? Yes, but you can never charge fees on the front end as a condition of approving an assistance animal. That is something that we do sometimes see. You can't charge front end fees when no damage has occurred. It is your practice to assess for damage and charge at the time it's discovered, then you can follow your normal practice there. If it's above the normal cost of wear and tear, you could be assessing them for those costs if that's your normal practice. What if they request an animal and then they won't engage in the process? They just give me an ID card, or they tell me they can't ask any other questions. And this is where we would say you can refer them to Fair Housing Center. We can do some education to help them understand their fair housing rights and help them understand what they need to do in order to make a request as it's outlined in the HUD guidance. So hopefully that was helpful. It is just about 11 o'clock. I'm going to stay on and answer some questions, but want to give you quick information here. We've got wonderful links throughout the PowerPoint. Here's a specific set of links to MSHDA resources. Again, thank you to MSHDA for sponsoring this training. We have tons of information on our resource page. You can sort by protected class, by language, by topic. You can search by keyword. So check out our resource page there. We also have lots of information on laws, lots of upcoming information on trainings on our trainings page. We're going to do a big conference online in April to celebrate Fair Housing Month. So we have lots of good things coming your way. We'll put the link to the evaluation in the chat right now. It should also be open in your browser. So each individual who wants a certificate and who wants to verify they attended must individually complete that evaluation. So look to the chat for that link, and we will send that out as well. I'm going to ask you to please be patient with us once again for time to get those certificates out to you. We're a small staff and we are working hard to get as many out as we can, but give us at least a month and you will get them. But you must complete those individual surveys. So going back to our questions, are we seeing any risk of changes with protected classes or fair housing in general? At this moment in time, because we do have Michigan protections for sexual orientation and gender identity or expression, those of us in Michigan aren't seeing changes, but that was something that has been addressed by an executive order. So the warden memo that did expand the definition of sex under federal fair housing protections has been rescinded by an executive order. So that is one change that we have seen, but we have Michigan laws that now layer those protections in. So in Michigan, it doesn't change anything. Those of you outside of Michigan might have to do a little more homework about protections. Are you allowed to use translation apps for communication with LEP individuals? I think that makes a good alternative, especially for unexpected communication, but it depends on what is being communicated. If it's technical or legal information, that may be something that may require a interpreter. It also depends on how you're funded. So hard to answer that question briefly. There's a couple of things that need to be evaluated, but hopefully that's helpful. Where do you find the list of when you have to provide written translation? So good question about tenant population and thresholds. For example, 7% speak Russian and now you need to provide written versus just verbal. I think it would be a good idea to look at that DOJ compliance link that I mentioned earlier and look at the meaningful access sections. There's steps to help you evaluate that. I'm not aware of a specific list, but that's the guidance that I think would take you in that direction. So I hope that's helpful. As of now, our practice is not to avoid any retaliation against previous landlords where a situation may have gone wrong. Oh, okay. So a little more detail on something we answered earlier. Thank you for that. Any suggestions for someone who doesn't speak English and also can't read? I think, that may take a little bit more research and depend on the unique needs of that individual. If they have any supports that can be engaged and brought in to assist with their consent. I know we make sure that we only advocate or make calls on behalf of people who have given us permission to do that. But we have dealt with very unique situations. And so we've relied on, I think we were able to find a sign language interpreter in Polish, for example, through Voices for Health. So I would start with those resources. And then if you have unique needs, you can reach out to us and or your local fair housing center to see what other resources are available. Sign language is a great way to communicate, so it's great that you have some ability. I have very limited alphabet ability myself. Can an assistance animal request be denied if the tenant has a revolving door of different animals? 4 different emotional support animals have come and gone in 6 months. Also, can we request re-verification after a reasonable amount of time for non-visible disabilities? So I think we would need more details on what exactly was happening in terms of the animals being moved in and out. I think that's something we would maybe want to do more one-on-one consultation with as to why that's happening and if that can be explained in a way that is reasonable or not. And then can we request re-verification? If the documentation references that the healthcare professional will be revisiting the recommendation, you may choose to engage in that, but I generally don't see it as a best practice because that can be very time consuming, especially for large properties who have made multiple accommodations. And so doing annual verifications risks collecting more disability-based information when you already have what you need and a few other kind of risk elements there. So quick answer to that, but hopefully that's helpful. What if we require tenants to carry renter's insurance? Should they contact their insurance provider to see if it would be covered on their insurance? I'm assuming that's related to the animal question, and I'm not sure I'm understanding any requirement that's an add-on. If that insurance provider said we'll cover this animal, but they have to pay $50 more a month, that would be a violation. So hopefully I'm getting at the heart of that question. When someone receives Social Security and asks for a different rent due date, do we have to accommodate that? It has to be a disability-based need and a person with a disability making the request. So if it's disability-based income, that would be an accommodation that needs to happen. If there's no disability or disability-based need, it's not an accommodation under fair housing law. On the tick, if the applicant doesn't want to list a gender or identity with either, can we leave the gender information blank or is that a finding? I think if you could send us more information on that, I'm not familiar with what the tick is, so we need more information on that. So please do email us. I don't want to give information that would not be accurate. The calculation on square footage. Yes. So that was one of your handouts was an reasonable occupancy guidebook. So make sure you have that, email us if you didn't get the handouts. It's also on our website in the resource section. You can download a spreadsheet that will calculate the math for you. And all of that will tell you, the step-by-step directions is in the guidebook that you got on the email with handouts, and then you can download the spreadsheet from our website. So hopefully I have answered as many questions as possible. Appreciate you all joining us, logging in. I had lots of nice comments here. We're very happy to have had you. Stay tuned for more trainings and information from us.